Imagine sitting down to an exam designed to test your professional capabilities, but the first question asks you about the history of the date fruit. This isn't a trivia question from an episode of Jeopardy, but rather an actual question from an exam once given to police recruits in Washington, D.C. The test was known as Test 21. Although the exam was administered uniformly to all recruits, its use of certain cultural language and idioms had a discriminatory effect. The test disqualified a disproportionately high number of African American applicants. 4 times as many African American candidates failed the test than white candidates. The disparate impact resulted in a police department that was 80% white serving a city that was 70% black. In 1970, Davis was rejected by the D.C. Police Department. Davis brought suit in federal district court alleging discrimination. Davis argued that the department's recruiting procedures, specifically Test 21, discriminated against African American applicants by testing irrelevant knowledge more familiar to white people than African American people. This, according to Davis, violated the Equal Protection Clause, as well as the employment discrimination provisions of Title VII of the Civil Rights Act. The district court held that Davis wasn't entitled to relief. Although the test produced a discriminatory effect, the court found no evidence of discriminatory intent behind the test. On appeal, the Court of Appeals reversed. The appeals court held that under Title VII, proof of discriminatory motive wasn't required. The court also determined that the same standard applied to the constitutional issue, so the lack of discriminatory intent behind Test 21 didn't bar Davis's claims. The appeals court reversed the district court ruling, finding that the test's disparate impact on African American candidates was enough to establish a constitutional violation. The United States Supreme Court granted the police department's petition for cert. The issue was whether a state practice with discriminatory impact is enough to violate the Equal Protection Clause of the 14th Amendment, or whether the practice must be shown to have been motivated by invidious discrimination. Justice White, writing for the 7-justice majority, held that discriminatory impact, standing alone, isn't enough to invalidate an otherwise neutral law or regulation under the Equal Protection Clause. Rather, the challenged provision must have been motivated by invidious discrimination. Justice White first noted that the Court of Appeals incorrectly applied the rigorous standards of Title VII, under which a showing of discriminatory purpose isn't required to the constitutional issue. He explained that the Supreme Court had never struck down a law merely on grounds of disparate impact, but instead always considered whether it also reflected a discriminatory purpose. In some cases, a strong discriminatory impact can be evidence of a discriminatory purpose, but discriminatory impact by itself doesn't violate the Constitution. Turning to Test 21, Justice White found no evidence of discriminatory intent. The test itself was neutral on its face. Additionally, the police department had made significant efforts to recruit African American officers, and the test was designed to serve the legitimate purpose of ensuring all recruits had a minimum level of competence. Justice White also rejected Davis's Title VII claim. Even though a showing of discriminatory impact was enough for a statutory violation, the police department could respond by showing that the test was directly related to success in the police training program. On this point, the court deferred to the district court's factual conclusion that the necessary relationship was established. The court reversed the judgment of the Court of Appeals, agreeing with the district court that Davis had no constitutional or statutory grounds for relief. Justice Stevens wrote a concurring opinion. He observed that the line between discriminatory purpose and discriminatory intent was less bright than the majority suggested. Nevertheless, he agreed that a constitutional violation doesn't arise whenever a disproportionate impact is shown. Justice Brennan dissented, arguing that the decision should have been affirmed on statutory grounds. He reasoned that the evidence before the court was insufficient to establish that Test 21 measured job-related skills and thus constituted a discriminatory employment practice under Title VII. Therefore, the court could have and should have avoided the constitutional question altogether. By emphasizing the constitutional significance of discriminatory intent, Washington v. Davis raised the bar for plaintiffs bringing discrimination lawsuits.